So we're going to talk a little bit about what happens when the adjuster from the carrier says they don't accept, won't accept, or just don't agree with the information or evidence you've submitted. This is an important distinction to make and an important concept in claims handling, because not accepting information and not agreeing with information that have been submitted to the claim file are two very, very different concepts. If an adjuster or a claims handler says they won't accept, that implies that they refuse to review, and that's a very big problem. However, most of the time when they say they don't accept, they actually mean they don't agree. So in claims handling, the insurance carrier has a requirement to investigate. They have to look at all the evidence that comes in. This is why if they refuse to review evidence, it's such a big problem. The insured or the policyholder has a requirement on their end, and that's to prove their claim. If they provide documentation and evidence, the carrier, the adjuster, the claims handler is required to review it before they make a decision. If they make a decision based on all the evidence in the claim file, you can discuss the interpretation of the evidence, but then you have a problem if there's a disagreement. However, there's room for discussion, because if you've submitted a report, for example, a roof report, and your roof report says this shingle isn't made anymore, or isn't compatible, or isn't repairable, and the adjuster says, I don't agree, that's his or her right. However, if the adjuster then wants to make a denial, which is a formal statement, wants to make a denial, in many states, they can't just outright deny the claim, because there's evidence, that's the report that you submitted, there's evidence in the claim file that says something. The insurance company has to disprove the evidence in the claim file. So the next step from the policyholder or the policyholder's representative, whether that's a public adjuster, a lawyer, or some other legal representative, should be to require an explanation. That's using the facts of the claim and the relevant policy language. The relevant policy language should be pretty easy to obtain. The language is what the language is, and the policy is what the policy is. However, facts of the claim go back to the investigation. If the adjuster or the claim handler does not have evidence of his own to refute what the policyholder or what you are presenting, then the facts of the claim don't support a denial. This is the foundation for an effective challenge to when the adjuster says he doesn't agree or she doesn't agree or the decision is unchanged. Because the question you should be asking is, the decision is unchanged based on what? It's always based on the investigation of the claim. Well, the investigation of the claim is based on the facts of the claim. If you've properly proven your claim using evidence, using documentation, and the adjuster or the claim handler is issuing a denial, but the denial doesn't have anything to counter your evidence, that's a big problem for the insurance carrier. You should be aggressively pursuing counter evidence from the insurance carrier, from the adjuster, from the adjuster's vendor. They don't necessarily have to provide you the actual evidence, or they should, but they don't necessarily have to. What they do have to provide is an explanation of that evidence, a description of that evidence. They might try to hide it, they might try to shuffle it off elsewhere in the claim file, but they do have to describe it. They have to explain it, and depending what state you're in, they may even need to tell the policyholder how to obtain it. That's very state dependent, so check your laws. To recap, remember, the adjuster is not required to agree with you. When he or she says that they don't accept your evidence, usually what that means is they don't agree with your evidence. And so your next position should be make sure you've actually proven your claim, you have legitimate evidence documenting your position, and then look to see what counter evidence the carrier has provided. If they have provided none, you are in a strong position. At the very least, you need to demand the adjuster, the claims handler, the carrier, provide documentation to refute you. Otherwise, a denial cannot stand because the facts of the claim support the policyholder. If you have questions, email, text, call, leave a comment on this video. As always, check your local laws. Please read your policy. And I'll see you around the horn.